On this week's episode of Ask the Expert, we have Christopher Charles Esquire, fancy word for attorney. He is the founder and managing partner of Provident Law. He's also a former broker hotline attorney for AAR, which all of our brokers use. Serves as an arbitrator and mediator for AAR. Teaches CE classes for the Arizona School of Real Estate and Business. And more importantly, he's our attorney for the Recon Group. So just ask him. He's a very, very big deal. Christopher, thanks for jumping on. I wanted to just get right into it. A couple months ago, we don't need to get into the details of the Arizona Supreme Court ruling, but a few months ago, especially for those of us that work with investors, HOAs have had just, full run. They get to rule the roost and make up rules as they go along, really inhibiting property owner rights, especially when they come down to short-term rentals. So the Arizona Supreme Court came out with the ruling. It was a Calway-based Calabria HOA. The ruling itself wasn't, or I should say the case itself wasn't specifically pertaining to short-term rentals, but there are far reaches, in my opinion, a huge blow to HOAs. In a nutshell, what was this case about and how does it impact us as property owners inside an HOA?
Well, thank you, Mike, very much for the opportunity to be with you and your listeners today. Happy to talk about this landmark decision issued by the Supreme Court earlier this year. It is, I think it is helpful in that it provides guidance and certainty for property owners and for HOAs as well. One of the principles that we hold very dear in this country and in our state, Arizona, is this idea of due process and private property right. The reason why Calabria, the Calway case, is helpful in giving guidance is that it sets a pretty bright line boundary for what HOAs can and can't do with regard to adding new restrictions to the deed restrictions, which are commonly known as CCRs, covenants, conditions, and restrictions. So the idea being that when a property owner purchases a property in the state of Arizona that is subject to CCRs, it's fair and reasonable, appropriate to enforce those deed restrictions, okay? Because the homeowner had notice before they bought the property that these deed restrictions existed and these limitations were there. So, but what has been happening, for decades, CCRs will be amended from time to time, but specifically what has been happening the last 7 years, 8 years, at least that's when I noticed short-term rentals gain, pretty serious popularity in Arizona, was around the time that the Super Bowl was here last. I think it was 8 years ago.
I remember that, yeah.
So since that time, there's been this trend of HOAs seeking to amend their CCRs to actually add a new restriction, to impose a brand new restriction on the property owners. So the question that is raised it was first in the Dreamland case at the Court of Appeals, and then now in the Calway decision in the Supreme Court, the question is raised: what needs to happen? Under what circumstances will CCR amendments be enforceable?
So case in point, my wife and I, we bought our house that we live in. About I think 4 years ago, and then literally within 30 days of moving in, the HOA amended the CCRs to actually restrict my ability to turn my house into an Airbnb one day. When I bought the house, that restriction wasn't there. Now all of a sudden it is there.
Right. So the Supreme Court now has given us a new rule that says, quote, any amendments to CCRs, in order for them to be enforceable, they must be reasonable and foreseeable based on the original CCRs that were present when the property owner purchased the property. So the CCR amendment must have been reasonable and foreseeable. One of the important quotes is that the Supreme Court indicates that an HOA cannot create new affirmative obligations where the original declaration did not provide notice to the homeowner that they might be subject to these new obligations, end quote.
So like in my case, because I got excited When I got your original blog, I'm like, oh, now all of a sudden, my house, I'm going to turn it into an Airbnb when I move out. So, and you offer a very special service for a set rate. Sent you my original CCNRs, which I was able to acquire from my title rep. And so you went and took a look at my original CCNRs. And unfortunately for me, because there wasn't language specific to short-term rentals in the original CCNRs, but there was language in there pertaining to rent restrictions, which then allowed them to amend the bylaws. So I went from a hero to, I should say, you went from a hero to a zero in my mind in a couple of minutes. So now I know, and your advice was you run a risk, but where there's other people, you take a look, you examine the original CCNRs, there's nothing in the original language. And my warning to all of us as real estate agents, we aren't attorneys. We should never examine the CCNRs and issue a ruling or a recommendation for our clients. That's what we have attorneys like Christopher Charles here to do. But there's a lot of people, when they take a look at the original CCNRs, no language in there pertaining to any type of rental rules, restrictions. And now if they've now voted on and amended the CCNRs, according to you, the Kalway vs. Calabria ruling states now those new amendments could be null and void.
That's right. And yeah, your situation, Mike, was unusual.
Okay, so we've had a couple months of this ruling and everybody getting excited and everybody weighing in. Where are we at today? Are HOAs making any movements? What are we seeing HOAs doing? Are we seeing a lot of HOAs starting to back down? Has there been any fallout?
Now the HOA attorneys have guidance on how to advise their HOA boards on whether they can move forward with amendments or not. So what we have happening now is a lot of HOA boards, understanding the reality of the situation, that they can't unilaterally as a board pass a resolution. That's unlawful under Arizona law. Now they can't do an amendment either. So they're trying to grapple with restrictions. So I see boards moving, kind of pivoting a little bit and saying, okay, short-term rentals are here to stay in our neighborhood. What can we do to try to ensure that there's no party houses and things like that?
Okay, maybe now HOA or short-term rentals are permitted in an HOA doesn't mean that you don't have pesky neighbors that are going to make things very, very difficult for you. And I know the city of Scottsdale, they just set aside X amount of dollars to create the Airbnb posse. And they are ready to just jump on when neighbors complain. They're going to be over there issuing citations because
you're right. It was 2016, Ducey signed SB 1350, which really opened the floodgates for short-term rentals in our state. And that initial bill actually expressly referenced that the state, the city, the municipalities, county cannot restrict short-term rentals, but HOAs can. Now subject to Calway, they can, kind of. So what can property owners do? What can property managers do? The best approach, of course, is to be a responsible operator and designate an agent to timely respond to any of these complaints. The operators want to make sure that they have a well thought out and drafted short-term rental agreement that can be uploaded into their platform that they're using, whether it be VRBO or Airbnb or their own platform. They want to make sure that they enact some type of noise monitoring device, such as Noise Aware, or there's several others now. Quiet hours, that type of thing in your rental agreement, and build, do the best you can to build relationships, build bridges with the neighbors. But that's why I think it's helpful to have a thoughtful short-term rental agreement that you insist that your guests use. Also, that will have occupancy restrictions and things like that, so that the operators can show the neighbors, hey, look, this is not a party house. We're responsible. We want to be a good neighbor. This is what we require all of our guests to comply with.
All right, last question. So let's say one of our listeners now has an investor They're looking at buying a property anywhere in Maricopa County, or I guess the state of Arizona for that matter. It's in an HOA. They're wanting to acquire a property to turn into a short-term rental. And, now with Kalway based Calabria, they don't know. What's that process in order to get your legal opinion on whether that investor should, or not gonna say should, but it'd be safer to buy that and convert it into a short-term rental?
Well, I just had a consultation with a owner immediately before this meeting, and regrettably, this owner, notwithstanding his best intentions, he did purchase a property that was specifically to be used as a short-term rental in Scottsdale. Had that intent from the beginning. He was shopping, for several months until he found this property. He bought it, furnished it. He did some improvements. So he did, significant. You can relate. He did a significant investment into this thing, about $100,000. About 2 months later, he got a cease and desist letter from a group of neighbors, and they contacts me, and I have to give him the bad news that, unfortunately, this property is subject to a restriction, probably is enforceable. I just wish that he would have called me, 3 months ago. So to answer your question directly, I mean, that I do think that is prudent step for investors to do before they close on a transaction, before they submit an offer even.
Well, or at the very least, get it done during the inspection period.
That's right. You've at least got 10 days typically to do that. But yeah, definitely call me, call a real estate lawyer, and just usually, 30 minutes, the attorney can tell you, yes, this would be a good property for you or not.
All right. Real quick, what's your favorite attorney joke?
Next subject.
All right. Christopher Charles with Provident Law. Thanks so much. Appreciate your time.
All right. Thanks, Mike. Appreciate being with you.